Hello and welcome. Today, we're diving into the architecture of digital justice. This explainer is based on the work of Professor Vihar Kiskinov, and together, we're going to map out how our legal systems are, or should be, adapting to our new virtual age. You know, at the heart of this entire transformation is one fundamental question. How do we take the core principles of justice, fairness, due process, all of it, from a world of paper and ink and translate it into a world of pixels and algorithms? How do we make sure those rights aren't just lost in the code? To get to the bottom of that, we're going to follow a really clear blueprint. First, we'll define what a digital proceeding even is. Then, we'll look at how different states are building their digital frameworks. After that, we'll tackle the crucial partnership between humans and algorithms. And finally, we'll lay out a blueprint for a unified European approach. So let's get started. Okay, let's begin with part one, really understanding the language of digital law. It is absolutely essential that we get our definitions straight before we try to build anything. You'll hear a lot of terms thrown around, but they are not the same thing. Telematics really just focuses on communication. Digital justice, that's more of a broad political goal. Law tech is a commercial buzzword. And if you hear this stuff talked about as mere business processes, be careful. That kind of management speak risks overlooking the fundamental legal guarantees we need to protect. So the big takeaway here, precision in language is the very first step to getting the architecture right. Now, what's really interesting here is the difference between just digitizing paper and creating something entirely new. This shows a digitally native procedure. This isn't about scanning a paper form and emailing it. No, this is different. Here, every single step, from filing the claim all the way to reaching a resolution, is designed from the ground up to exist and function entirely inside a virtual environment. And that brings us to a more formal doctrinal definition. A virtual legal proceeding is conducted by IT, where legal decisions are formed either by people or, and here's the kicker, automatically by technology. Now that last part, that's the real challenge. How can an algorithm form legal intent? Well, it requires what we call a legal fiction, basically a framework where the law agrees to treat a specific automated act as if it were a valid expression of will, just like a person had done it. Okay, so let's move into part two and see how all this actually gets built into national systems. We're going to explore the different architectural models for putting together digital governance across Europe. Broadly speaking, we're seeing two main approaches pop up. On one hand, you got Spain's integrated model. They build the digital rules right into their existing legal codes, which is great because it makes digital the default. On the other hand, you have Germany's two-tiered model, where they create separate, special e-government laws. Now, that can be more flexible, but it runs the risk of creating a legal landscape that's fragmented and maybe even inconsistent. So, how are these rules actually made? Well, there are three methods. The first, reproduction, is just taking old paper rules and slapping them onto a screen. It's often clunky and inefficient. The third is an IT-first model, where the tech gets built and then the law tries to catch up and describe it, which can easily clash with core rule of law principles. The best, most sound approach is the second one, the juridical model. This is where legal principles and rights guide the design of the technology from the very start. The law has to be the architect of the system, not the other way around. And that leads us perfectly into part three, the critical, and I mean critical, relationship between human judgment and automated systems. Where exactly do we draw the line? For many procedural actions, full automation isn't just acceptable, it's actually a huge improvement. Think about all the routine tasks, sending out automated notifications, processing standard applications, issuing a summons, or just checking a case file to see if all the documents are there. These are mechanical tasks that really benefit from the speed and consistency of automation. But, and this is a huge but, there is a clear line in the sand. Any action that requires a value judgment, evaluating human behavior, interpreting complex facts, or making a decision that stops or fundamentally changes a legal case, that cannot be fully automated. These moments demand human discretion, empathy, and oversight. For any system that calls itself just, this is a non-negotiable principle. And look, this isn't just abstract theory. This is a perfect illustration of these principles being put into practice right now. Take a look at Bulgaria's upcoming Administrative Procedure Code reform. You can see how the theoretical needs of a digital system, things like electronic filing, mandatory e-dossiers, and even new rules for serving documents digitally, are all being written directly into law. It's a real-world validation of the models we've been discussing. So, with these foundations firmly in place, we can turn to our final section, Part 4, what a blueprint for a harmonized digital justice system could look like across the entire European Union. A proposed EU regulation would be built on 4 core principles. Digital by default means public bodies have to offer electronic options. The one's only principle is the one that saves you from having to submit the same info over and over again. And most critically, it would enshrine human control over key decisions and the right to transparency. Your right to understand how and why a decision about you was made. When it comes to AI specifically, this draft regulation gets very granular. It actually defines what an AI-assisted decision is. It flat out prohibits full automation for any judgments on complex facts or human behavior. It requires a meaningful human review of AI recommendations, not just a rubber stamp. And it puts the right to an explanation from the AI Act into practice, giving people the power to ask why a system made the recommendation it did. So, where does this all leave us? The road to digital justice is, without a doubt, complex. But what this work makes incredibly clear is that technology has to serve the law, not the other way around. The conclusion is simple. Building a solid and pan-European legal foundation is the mandatory and urgent first step. Thank you for joining this explainer.